Yes, Your Honor.
Yeah, okay, please, the live stream has started, or do you need a minute? No, live stream is okay, so please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Meta Platforms, Inc. et al., case number 24 AP 295. Representing the appellant, Meta Platforms et al., is attorney Mark Mosier. Seated at counsel table with attorney Mosier is attorney Kendall Burchard. Representing the appellee, the state of Vermont, is attorney Roger Perlstad. Seated at counsel table with attorney Perlstad is attorney Jimmy Rock.
Okay, thank you very much. Good morning, counsel. Thanks for your patience. Appreciate you being here. We'll hear from counsel for the appellant first. Please come on up to the podium. And before you start, if you would introduce yourself and identify your client.
Thank you, Your Honor. May it please the court, Mark Mosier on behalf of Meta, plan to reserve 3 minutes of my time for rebuttal. The Superior Court should have dismissed this case for lack of personal jurisdiction. The state does not dispute that Meta is not subject to general jurisdiction in Vermont. There's no allegation that Meta has any offices in Vermont, any employees in Vermont, or owns any property in Vermont. The state instead seeks to establish personal jurisdiction based on specific jurisdiction. To do that, the state needs to allege a substantial connection between the claims in this case and Meta's contacts with Vermont. For the state's first claim.
Just so I understand the consequence, I think I have a question, which is that is the effect of your position essentially that you are not subject to the Vermont Consumer Protection Law at all, no matter what the issue was or where it came from?
No, Your Honor. We don't dispute that the state could bring claims in California, which more than 30 other state attorneys generals did. There's currently a case pending in the Northern
But
District.
it wouldn't be subject to the Vermont Consumer Protection Law if you did that, right?
It very well may be. That would be a separate issue. That would be a choice of law issue. And so far in the proceedings in the California court, Meta has not challenged that each of the 29 attorneys general who is currently pursuing claims in California, each can do so under their own state's Consumer Protection Act. The United States Supreme Court has made clear in cases like Schutz that the issues between personal jurisdiction and choice of law are distinct.
I understand they're distinct. I'm trying to understand how I could stand before a court in California and say, this is my reason for saying that they violated the law of Vermont and you should enforce it. I don't understand any choice of law principle that would allow me to get away with that.
So that's currently proceeding in that manner in California under the questions, and in part it's because choice of law principles often put more weight on where a plaintiff alleges the injury occurs than personal jurisdiction does. You know, a related point why we do concede that Vermont could bring suit in California, I want to make sure to address something that the state said in their brief, which is that our position would mean that only suits could be brought against Meta in California. That's not our position. There's roughly a dozen suits like this in courts around the country, and in several of them, Meta has not contested personal jurisdiction.
For what reason?
So Massachusetts would be a good example. There, the Massachusetts Attorney General alleged that Meta has offices in Massachusetts. It has employees in Massachusetts, and those employees are working on issues related to the safety of Instagram. Where I was going with the test for specific jurisdiction, there needs to be alleged a connection between the forum and the specific claims here. The specific claims here are that Meta designed Instagram by including features that are addictive. There's no allegations that the features that the state challenges were designed in Vermont. There are allegations, as pled in other states, including Massachusetts, that the employees in those states are working on the safety in Instagram. Our position is not that Meta is only subject to suit in California. It's that if your claim, which is the state's claim, is that they want to challenge the way that Meta designed Instagram, they have to allege facts to connect the forum to the design of Instagram. There's no doubt that substantial part of Instagram was designed in California. Suits can be brought there. In several other states, Massachusetts, Florida, the District of Columbia, the attorneys general alleged facts to link the design of Instagram to those forums. In those forums, there was no challenge to personal jurisdiction. We have only challenged personal jurisdiction in the forums where there's nothing specific about anything that happened in that forum that relates to the claims.
So let me go back to my original question and just add something to it. If the legislature passed a statute that essentially prohibited exactly what the Attorney General is trying by this decision to get prohibited, would the result be the same? That would be a useless statute,
No,
except you could go to some California court and try to get them to apply or essentially answer a case solely based on that statute.
so again, yes, if there was a statute, we would apply the same analysis. We are not asking this court even to adopt a rule that's saying that Meta could never be subject to personal jurisdiction in Vermont. All we're saying is you have to look at the factual allegations in the complaint. So if you had a different
But the passage
statute,
of the statute wouldn't be enough by itself.
the passing of the statute by itself would not be enough to establish personal
Could
jurisdiction.
Vermont ban Meta from, because of this situation, from operating in Vermont?
We would have serious like First Amendment arguments, and we would argue that they could not, consistent with the First Amendment, ban Meta,
It's
but that
the-
would be,
If it's the only effective way to get at the problem, why not?
so we think it would be an effective way to get at the problem to bring suit in a court that has jurisdiction. We think it would be, a majority of the state's attorney generals across the country have brought suits like this in California. So that would be if the state wants to bring these claims, they can. We're not even asking the court to say there is no allegations that any state could ever allege that would subject Meta or another defendant to personal jurisdiction. What we do now for specific jurisdictions, we look at the allegations in this complaint. Is there anything in this complaint that sufficiently ties?
So I don't have the complaint in front of me, but I do have a note to myself about what the state alleges in their brief, which I assume parallels with what they've said in the complaint. And you said a few minutes ago that they have to allege facts connected to the design in order to get specific jurisdiction. Well, in the brief, they say rather than requiring users to pay dollars to use it, appellant generates revenue by selling ads targeted to users based upon data collected. Collecting data is in its terms of service. The more time a user spends on site, the more data collected, the more ads it displays, the more profit. So isn't that related, assuming that this is parallel to what they allege in their complaint, isn't that related to, in fact, the design of your product?
It's not, Your Honor. And if I can break that into parts. So one of the
Forgive me,
allegations.
but I don't have a way to plug this into my ear, so
Okay.
don't let that distract.
Sure. Part of the allegations, as Your Honor read, is that in order to use Instagram, users agree to the terms of service. And so kind of form a contract in exchange that Meta is able to collect information about them. With respect to the related to prong, courts have held, and I think correctly so, is that a claim is not related to a contract or to terms of service when there's no allegation that there's anything unlawful or wrong with the terms of service. There's no allegation that there's breach of the terms of service, that the terms of service are deceptive, that they are unfair. The claims at issue in this case have nothing to do with the terms of service.
They're alleging that the design of your product, as I understand it, is targeted to generating revenue by selling ads that are related to the data that the product is collecting from users of that product. Isn't that all design, whether or not what you say in your terms of service, aside from that, isn't what I've read to you related to the design of the product itself?
It's not related to the design, certainly not in the case of what their claims are about. Their claims are about the allegations that the design is addictive and that it's unlawful. It's not related to even the use of the product in the sense of what
No, isn't it-
information.
If you're addictive, it means there's going to be more use. And the claim of the state is that more use is what is the problem here. That it results in negative consequences with respect to children. We're talking about youths, children generally. Mental health, educational experience, any of that, if you spend all your life on your Instagram. And that is the business model, which is that you get paid by the subscribers, the ad providers, based upon how many hits go to there, and the number of people on is what determines the number of hits. Isn't that the model, and isn't that the connection?
So that is the business model that's alleged, but courts have rejected kind of establishing personal jurisdiction by looking at the business model overall as opposed to what the claims are and what's alleged to be unlawful. I think the best.
Haven't many courts adopted that, the business model in making these kind of decisions? I
So-
haven't heard that it's often been rejected.
So I would say it's inconsistent with the Supreme Court's decision in Bristol-Myers Squibb, which I'll talk about. It has been expressly rejected by the Third Circuit Court of Appeals in the Hassan case and by the Fifth Circuit Court of Appeals in the Johnson versus Huffington Post case. And I want to talk about the Jeff Johnson versus Huffington Post case because the allegations there were really identical to what we have here. But first, let me start with Bristol-Myers Squibb since it's the United States Supreme Court. There, the plaintiffs attempted to establish specific jurisdiction in California. Obviously, Bristol-Myers Squibb is one of the largest pharmaceutical companies in the world. They had hundreds of employees in California. They did over $100 million of business every year in California. Still no specific jurisdiction, even though that was obviously the business in California was important to its business model because the court looked at the specific claims there, said there wasn't enough of a connection to the activity in California.
So, Mr. Mosher, are you arguing then that there has to be a causal showing?
No,
Okay, you're not. All right.
no.
I just want to make sure I understand that. Right.
Did Meta conduct any Vermont-specific research on teen usage, young people usage?
There's no allegation of that. The discussion of the research in the complaint says that Meta conducted a national study of use by teens. And then the allegation says, obviously, if it's a national study, it would include teens in Vermont. But there's no allegation that Meta did anything in that study as far as redesign Instagram to target Vermont teens. So the allegations regarding the study is regarding collecting data of national usage. And so if I could return to the.
Back to the point, though, you just made, isn't there evidence, or at least, of course, we're at the stage in which we're dealing entirely with a motion to dismiss, and we don't have the evidence yet of this. But isn't the state's evidence, it claims, is that you knew that the result of overuse of this by teens, children, what had considerable concerns as to mental health and other things, and you went forward with it anyway. The only issue about targeting is that it wasn't specifically designed with Vermont in mind. It was specifically designed with everywhere in mind, and is getting an everywhere response. And part of your argument here seems to be, if it's everywhere, you're immune. If they had just done this in Vermont, you'd agree.
So a couple points on that. Certainly there are allegations that Meta knows of usage in Vermont. I think the Bristol-Myers Squibb case I talked about earlier shows that that's not sufficient. Obviously, Bristol-Myers Squibb knows that there's substantial business in California. Our argument is not that because Meta does business everywhere, it's not subject to personal jurisdiction anywhere. As I talked about earlier, there are a number of states in which we haven't contested jurisdiction. And here, I think maybe it helps to talk about the analysis in Ford. Your question, Your Honor, was going towards Ford. And I think it's important to start with what Ford didn't say. The Supreme Court could have said, Ford is the quintessential American automaker. It has been for a century. Ford cars are sold everywhere. Ford advertises everywhere. Everyone knows of Ford. Ford is subject to personal jurisdiction everywhere. That's not what the Supreme Court said. It said, in order to determine whether courts in Montana and Minnesota have specific jurisdiction over Ford, we have to look at the specific factual allegations of what Ford did in Minnesota, what Ford did in Montana, and see if there's a connection between these claims and the activities in Minnesota and Montana. And what the Supreme Court determined is that Ford puts up billboards in Montana and Minnesota. It has service centers in Montana and Minnesota, and it ships replacement parts into those states. And more specifically, all of that conduct was aimed at the two vehicles that led to injuries there. And what the Supreme Court said is that because of the connection between the injuries suffered by driving these two cars and the specific conduct alleged in those states, there was personal jurisdiction there. It was irrelevant to the analysis, everything that Ford did in every other state. I see that I've used up my time and I was hoping to say some for rebuttal unless there's further questions.
Okay, thank you. We'll hear from counsel for the appellee. Please come on up. Please, for the record, introduce yourself and identify your client.
Morning, Your Honors. May it please the court. My name is Roger Perlstad, and I represent the state of Vermont. Meta has been remarkably successful in Vermont. More than 41,000 Vermont teens use Instagram monthly, and almost 30,000 use it daily. Instagram has almost fully saturated the market for Vermonters under 35 years of age, and more young people in Vermont use Instagram than any other state per capita. The state alleges that Meta has caused great harm to these young Vermont users by incorporating addictive design features into Instagram and misrepresenting and lying about the safety and known dangers of the platform. Meta now argues that it is not subject to personal jurisdiction in Vermont for these claims. In other words, Meta argues that it can come into the state and sign up as many Vermont users as possible, try to keep those Vermont users on Instagram as long as possible using unfair and deceptive practices, collect personal information from those Vermont users, and use that personal information and the time they spend on the platform to sell advertising to companies seeking to target those Vermont users. And they argue they can do all of this without having to answer for the consequences of those actions in Vermont courts. The Superior Court properly rejected this argument, and this court should too. Let me start with a couple things that
I think it was the amicus brief that said that they had created a specific design aimed at Vermont. Tell me how they did that. What did they do that was specific to Vermont?
I think the most important part that's specific to Vermont is they are trying to get Vermont eyeballs. Their product is selling advertisements, and they want to sell advertisements
But they're trying to get everybody's eyeballs.
They want to
right?
get everybody's eyeballs. But the fact is they do get Vermont eyeballs. And the fact that they try to get everybody's eyeballs and not just specific Vermont eyeballs, although they do try to get Vermont eyeballs, the fact that Meta operates in exactly the same way in every state doesn't mean that it's not purposely availing itself of any particular state. That proposition is directly contrary to both Ford and Keaton out of the Supreme Court. Ford sells cars everywhere. Ford wants to sell cars all over the world, not just in Minnesota and Montana. Hustler sold magazines all over the world, not just in New Hampshire. But that didn't mean they weren't purposely availing themselves.
But the complaint in Ford, I mean, isn't Ford a parallel to this? The complaint is for design defect, failure to warn, falling or rollover in Montana?
Yes, exactly. We think Ford is directly applicable here and binding on this court, obviously. And I think the allegations are very similar. It was product liability, design defects, essentially. But Ford doesn't design its cars in Montana or Minnesota. It designs them in Detroit. builds them in Detroit and Ontario and wherever else it builds them. And then it's just, its business model is to sell cars everywhere, to advertise everywhere, to service cars everywhere, to sell cars, repair cars, sell parts in every state. So I actually think Ford rejects this idea, or Ford does not reject this idea of looking at a business model to determine personal jurisdiction. I think it's just wrong to say that courts have rejected the business model, looking to a business model generally. I think
a
Ford does that.
Vermont Instagram user see different content than someone in California?
Yeah, they will see Vermont ads. They will see,
So it's the ads that are different.
among other things, yeah, but specifically that we allege that Miss Vermont Teen advertises on Instagram, and they are looking to advertise to Vermont teens. They don't want to waste their money selling ads to California eyeballs or to Texas teens. They want Vermont teens to see ads for Miss Vermont Teen, and Instagram provides that to them.
But I think the meta argument to that is that you've never alleged that the content of the advertising has anything to do with your claim.
I think we have alleged that. We've alleged that this is exactly how Instagram works. It knows exactly where its users are, and it sells ads targeted to those users in Vermont.
Can I bring up the business model?
Absolutely.
Appellant's counsel said that the business model was not one that is often recognized, and I had a different impression of that. So what's your thought on that?
I agree. I think Ford doesn't explicitly use the phrase business model. I'm not sure. I'd have to go back and look, but I think that's certainly what they are looking at. They are looking at what does Ford do? Ford sells cars, it services cars, it advertises cars. That can be described as a business model. And then I think the Ninth Circuit most recently in Briskin v. Shopify, which came out after our response brief, but before appellant's reply, it's noted in their brief. In the Shopify case, the Ninth Circuit en banc specifically talks about business model. They say, quote, Shopify's business model is to perform payment processing services it contracts to provide for its merchants, and in the course of doing so, to obtain valuable personal data about California consumers for its own commercial gain. Ninth Circuit talked about business model explicitly, and the business model was similar. Provide service in exchange for personal information.
And does Keaton support that as well?
Yes, Keaton was selling magazines all over the place, and that was their business model, to sell magazines. Another thing I'd like to respond to is Bristol Myers Squibb. Appellants rely on Bristol Myers Squibb a lot. I think Bristol Myers Squibb actually supports our argument. In Bristol Myers Squibb, it was another product liability case. It involved the drug Plavix, and plaintiffs all over the country brought personal injury claims against Bristol Myers Squibb in California related to the drug Plavix. And the court held there was no personal jurisdiction in California over non-residents' personal injury claims because they didn't obtain or ingest or were prescribed Plavix in California. But the court noted that non-residents could have sued in their home states. The court mentioned there were a lot of Ohio plaintiffs, there were a lot of Texas plaintiffs. They could go to their home states. Even though Plavix had been developed and manufactured and packaged and labeled in New York and New Jersey, the court said, no, bring it in your home states, bring it in Ohio and Texas. And indeed, in Bristol Myers Squibb itself, the court noted that personal jurisdiction over California residents' claims was undisputed. So I actually think if you look at the whole context of Bristol Myers Squibb, that case supports us. Couple more things. Another argument that Meta makes is this idea that the state is trying to blur the line between general and specific jurisdiction, and that affirmance would leave Meta and other internet companies subject to suit in any state for any claim. But that's just wrong. Meta is subject to suit in any state in which it chooses to do business for any claim arising out of or relating to that business. So for example, while claims relating to Vermont teens' use of Instagram can be brought here, claims related to Texas teens' use of Instagram or Oregon teens' use of Instagram, they can't be brought here just because Meta also does business in Vermont. Those have to be brought in their home states or in California or Delaware, Meta's home states. And likewise, a whole other category of cases that aren't subject to personal jurisdiction here. An employee harassed at Meta's California headquarters or a vendor stiffed on a delivery in California. They can't bring a suit here just because Meta does business on the internet in Vermont. Those claims have to be brought in those appropriate jurisdictions. And again, I think Bristol Myers Squibb is a great illustration of that. California plaintiffs could bring in their home states against Plavix, even though Plavix was designed and labeled and packaged in New York and New Jersey. But non-residents could not. They would have to go to their home states or to to Bristol Myers Squibb's home state. I actually think Meta is the one that's blurring a line here. They're trying to destroy this line between specific and general jurisdiction. Because if the state can't bring these claims here, if the state of Vermont can't bring claims that Meta is harming Vermont teens by using addictive design features and misrepresentations to get them to spend as much time online and is causing real harm to Vermont teens in Vermont, mental and physical health problems in Vermont. If the state can't bring those claims here, then what's left of specific jurisdiction? I think another argument that Meta makes is this idea that Instagram is not designed in Vermont. None of the design features were created in Vermont. Again, I think Ford answers that question. Ford cars are not designed in Minnesota and Montana. They were designed in Michigan. The idea that Meta needs a physical presence or tangible goods have to be shipped in here, that I think doesn't matter either. I think the Supreme Court in the Burger King case rejected that idea. That case involved all the contracting was done by mail and wire between Florida and Michigan. And the court said that we've consistently rejected the notion that an absence of physical contacts can defeat personal jurisdiction. And I think just at the end of the day, the analysis comes down to two touchstones of due process. And the first is interstate comedy. And I think Vermont clearly, I think, has more interest in this case than either California or Delaware. As I've said, the state of Vermont seeks to enforce Vermont law for trying to protect Vermont teens. Just like in Ford, the state, quote, brought suit in the most natural state. This is the most natural state for this case. And so I think interstate comedy weighs in favor of, strongly in favor of personal jurisdiction here. And then the second prong of personal jurisdiction, just treating defendants fairly, I think also weighs strongly in favor of bringing suit here. Meta does business here. They enjoy the benefits and protections of Vermont laws. Vermont enforces contracts here. It defends property here. It creates effective markets here that Meta is able to exploit, and that creates reciprocal obligations. And I think it's fair to subject Meta to personal jurisdiction here. This court 30 years ago in Dahl v. Kaler said, quote, when sellers intentionally act to advance their commercial interest, they should reasonably anticipate being sued in Vermont if a dispute arises from these activities. I think that's exactly what's going on here. I think Meta is subject to personal jurisdiction in Vermont. If there's no more questions, I'll take my seat.
Thank you very much.
Thank you, Your Honor.
Thank you. How much time does the appellant have, please?
Appellant has 0 time remaining.
Call a conclusion of the case, please.
The next hearing